Our goal in writing this article was to think about some of the Supreme Court's recent output through the lens of disability, meaning in the same way that other scholars have thought about the cases through the lens of race or gender, to really see disability as a through line and ask what new might we see when we do that.
And one of the things that we did with respect to the disability lens is to possibly see disability in three ways. The first way is with respect to the facts or the law that the court engages with. And the second is, what's the impact of the decision that the court hands down, and what impact does that have on people with disabilities? And the third has to do with, how is the case framed? Did the litigators who first encountered the case have choices? The answer is yes, they did have choices about how to frame the case, what rights attach. And so through those three pieces, the disability lens gives us more nuance in terms of a Supreme Court decision and lets us see that the choices that were made along the way exist and were not inevitable.
Talevski was an interesting case for us to think about because it exemplifies what we see as a pattern in the case law, which is the court taking a disability-related case and using it to potentially remake a wide swath of law. In this case, law having to do with the rights of people who benefit from what we call spending clause statutes. So in general, that's just a huge swath of the welfare state. So this case, I think, came out correctly in that the nursing home did not prevail. So it wasn't a sort of disastrous outcome, but we think the case still is, again, evidence of a broader pattern.
Right, and the pattern, of course, is that disability, because it's often siloed in terms of legal scholarship, in terms of the media, and if people are not paying attention, they could miss the fact that disability anti-discrimination laws are based on other anti-discrimination laws which preceded them. And so because of that, the court, any decision that comes down that is handed down on disability may have ripple effects through, as Karen said, other forms of civil rights laws. And so you'll begin to see something like that happening. And so that's one of the reasons we came together to say we need to pay attention to what's happening through a disability lens.
I think the dissents in this case are also worth keeping an eye on.
That's right.
So the dissents of today are sometimes the majority opinions of tomorrow. So I think that's another reason why, even though we think it came out in the correct way, it's still a case that really is worth our attention. Part of our paper, and here we should mention our terrific co-author, Shira Wakschlag, is a disability rights litigator. And she really helped us see the ways in which, before this Supreme Court, people advocating for disability rights might be at a disadvantage. And so there's various litigation strategies that she helped us understand.
Right. One of the strategies was keep cases out of the court, to put it succinctly. But essentially, the idea is to use advocacy and coalition building and movements to keep the pressure on public entities, on private actors, to perhaps remove the litigation, to dismiss the litigation. And so there's a lot of precedent for that, even before the terms that we were talking about. One example is a case from San Francisco called City of San Francisco versus Sheehan. And that case was a huge case because it had to do specifically with whether the Americans with Disabilities Act applies to policing. Now that's a huge question, and if that went before the court, could have tremendous ramifications. And so the disability rights community mobilized and they protested and took to the streets in San Francisco and ultimately convinced the city of San Francisco not to withdraw the case, but to change the question before the court, which was a much more narrow question. Instead of does it apply, it was how does it apply? And the court did not think too kindly on that point.
But it prevented, I think, the making of potentially a bad precedent from a disability rights perspective.
Absolutely. And that strategy, do you want to talk a little bit about the strategy in CVS?
Yeah, we also write about a case called CVS versus Doe, where the disability rights community successfully convinced CVS to essentially withdraw that case from the Supreme Court's docket. So it was a kind of public pressure, community-based campaign to get CVS to essentially rethink the wisdom of bringing this issue up to the Supreme Court. In our article, we address some areas of law that I think are sort of obvious to look at from a disability perspective. Those include civil rights law more broadly, equality law, social welfare law. And there are some great colleagues in the academy who I think are bringing that disability lens to areas like criminal law, for example, family law. But I think there are lots of areas of law that where this lens hasn't been applied.
Right. I would say, in answer to that question, everywhere, every body of law.
Evidence, which you write about.
Evidence, exactly.
Administrative law.
Administrative law. So disability touches all of these areas of law precisely because the people with disabilities are so numerous and pervasive in society, and we haven't quite yet reckoned with that one fact. So 61 million adults in the United States have one or more disabilities. And that's a significant population. So when we think about what specific areas of law, as Karen said, I think all of them, but specifically you named a few. I think the private law fields, for example, bankruptcy law, I think is huge when we think about debt and debtors and disability. That's another area, hot area for the future.
A case that we're keeping an eye on for this upcoming term is called Atchison Hotels versus Lawfer. So this, from the Supreme Court's perspective, is a big standing case. It has to do with the standing specifically of what we call a tester. So in the civil rights context, that would be a person who is essentially trying to enforce civil rights statutes by going to an establishment and seeing if they are in compliance with existing laws. This is hugely important in the disability rights context. It's also important in the context of fair housing and race. So as in our paper, this is a case that is about disability, but with much wider implications.
Absolutely. And I think one of the key points here is also about the harm and understanding the nature of the harm in the context of disability. So with respect to testers generally, the value is that they do the work ahead of time and they show that someone's out of compliance so that the next person can benefit from an establishment being in compliance. That is so critical in the context of disability. If you are a traveler with a disability and you have expectations of something being accessible and you show up and it's not accessible, you don't have an effective remedy there at the time. Not only that in real time, but as a matter of law, you don't, because you can't actually get damages under Title III of the Americans with Disabilities Act. Everything is injunctive relief. And so the whole structure of the law is saying we need testers in order for this to function properly.
I think the question is, how are civil rights laws enforceable if tester standing goes away?
Right. I think they're not.